$10,000. You understand that?
Yes, sir.
There's a total of 7 admonishments. When you go over onto the second page, it shows in a signature down at the bottom. Is that your signature?
Yes, sir.
That signature is on all these plea documents. Some signed and sworn to. You did go over each one of these plea documents with Mr. Sanders, your attorney, before you signed and swore to it. Is that correct?
Yes, sir.
All right, so we've talked about your plea agreement. So if you plead guilty, the state's counsel is going to recommend 8 years in TDC. I'm going to follow that recommendation, assess the sentence at 8 years in TDC. It would be assessed with credit for time served in Smith County Jail. Then the cause number set out would be considered by the court, and then it would be dismissed by state's counsel. Is that your plea agreement?
Yes, sir.
Under the Acknowledgment of Admonishments, the second plea document, you've got your full range of sentencing set out, 5 to 99 or life fine of up to 10,000. There's a total of 7 admonishments. I'm not going to go through each one with you, but the 7th is right above your signature and Mr. Sanders. Do you understand all 7 admonishments, which are explanations?
Yes, sir.
You've gone over all these plea documents with Mr. Sanders. Is that correct?
Yes, sir.
Next document's your waiver of trial by jury, signed by you and Mr. Sanders. It tells the court you understand you have a right to trial by jury, whether you plead guilty or not guilty. And understanding your right to a trial by jury, you normally waive, which means give up your right to a trial by jury and just ask the court to hear the case on your plea of guilty without a jury. Is that correct?
Yes, sir.
Now, there's the next document's a waiver of confrontation and agreement stipulated against, signed and now sworn to by you. Do you understand that document?
Yes, sir.
Next document's the stipulation of evidence, stage 2, signed, now sworn to by you, signed by your attorney. That stipulation of evidence, stage 2, which will be coming into evidence in a few minutes. Do you understand that as a written judicial confession or admission under oath to all the allegations and the charge in the indictment?
Yes, sir.
And you did sign and swear to this stipulation of evidence, stage 2, of your own free will, sign and swear to it voluntarily. Is that correct?
Yes, sir.
Then there's an agreement to stipulate testimony, signed by you and your attorney, signed by Mr. Gerald. You understand the next document, it gives a waiver, meaning giving up. You're giving up your right to appeal, and you're giving up your right to file a motion for new trial on your plea agreement case. Do you understand that?
Yes, sir.
The court's already approved a waiver of the pre-sentence. There's a document correctly filled out, signed by you and your attorney. The trial court certification of your rights to appeal. There's an X, and this is correct, where it says this is a plea bargain case and you have no right of appeal. In addition, you have waived, given up your right of appeal. Do you understand that?
Yes, sir.
All right, now, there's the other plea papers just certified as advice you've received from your attorney on your rights to appeal. So understanding all these plea documents, understanding the allegations, the charge in the indictment, your plea agreement, do you still wish to go forward on your plea of guilty to the indictment now without a jury and ask the court to follow the plea agreement?
Yes, sir.
But I'm going to go through and ask you some questions. These are pretty straightforward, to say the least, but if you have any question about what I ask you, if you don't understand any questions, tell me and I'll go back over it with you, okay?
Okay.
All right, do you read, write, and understand English?
Yes, sir.
Have you consumed any alcoholic beverage in the last 24 hours?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir.
Have you ever been confined in a mental institution or under psychiatric treatment?
No, sir.
Do you understand everything you're doing in court today?
Yes, sir.
Have you been over everything you're doing in court today, as well as the facts of your case and all these plea documents you signed or signed and sworn to with your attorney, Mr. Sanders, who is here on the Zoom plea?
Yes, sir.
You competent, Mr. Sanders?
Yes, sure, she is.
Are any evidence of incompetence, Mr. Gerard? Let's see.
No evidence of incompetence, Your Honor.
All right. Now, Ms. Alanis, just to be sure now, you do understand all the allegations, the charge in the indictment against you, all of these plea documents, full range of sentencing, and your plea agreement. Is that correct?
Yes, sir.
Do you have any questions for me about anything?
No, sir.
All right, in cause number 241-0739-21, what is your plea today to the indictment charging you with engaging in organized criminal activity, a first-degree felony as alleged in the indictment?
Guilty.
Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Yes, sir.
Anyone threaten you in any way, promise you anything, or coerce you, make you plead guilty?
No, sir.
Are you entering your plea of guilty to this indictment today freely, intelligently, knowingly, and voluntarily because you committed the offense alleged against you in the indictment, engaging in organized criminal activity?
Yes, sir.
Are you entering your plea of guilty to the indictment today freely, intelligently, knowingly, and voluntarily? That's the second time I've asked you that, but I want to be sure. Is that correct?
Yes, sir.
Are you entering your plea of guilty to the indictment as a result of any type delusion you have in your mind or some type unrealistic hope of pardon, parole, or leniency?
No, sir.
All right, the court does receive and accept your plea of guilty. What do you have, Mr. Giral, or looks like you're left, Mrs. Giral? What do you have? I don't see.
Your Honor, I've got a spot.
Yeah, I'm not sure how you're on, Mr. Giral. Ms. Anderson was on. She's gone off. So you want to offer states 1, 2, and 3?
Well, I've got a,
I'm losing you.
yes, Your Honor, I've got a spotty connection, but I would offer stage 1, stage 2, stage 3 as evidence of guilt.
All right, thank you, Mr. Giral. Court approves. Any objection, Mr. Sanders?
No objection, Your Honor.
No objection. The court approves and admits into evidence stakes exhibit number 1, all the plea documents signed or signed sworn to by the defendant, signed by our attorney, signed by state's attorney. Those are all admitted in as states 1. States 2, that's the signed and sworn to stipulation of evidence, signed and sworn to by the defendant, signed by her attorney, signed and sworn to stipulation of evidence being a written judicial confession by the defendant to the allegations and the charge in the indictment. Stage 3, discovered compliance is proved by the court, admitted into evidence without objection. The court having admitted into evidence with no objection, stakes exhibits 1, 2, and 3. The court does find the defendant's waiver of her rights and her execution of all these plea documents were all done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find the defendant's plea of guilty entered to the indictment in this case was entered by the defendant to the indictment in this case freely, intelligently, knowingly, and voluntarily. The court does receive and accept the defendant's plea of guilty to the indictment, and the court does find the defendant guilty of the offense of engaging in organized criminal activity, first-degree felony, as alleged in the indictment. Moving to sentencing.
Your Honor, at this time, we don't have evidence. I'll run the digital copy of the written discovery down to the court at some point today.
That's fine, Mr. Terrell. So you're offering for purposes of sentencing all the discovery in the case, correct?
That's correct, Your Honor. We'd offer it as
4.
states P1 or states 4, I guess.
Yes,
And I'll get to the court a copy this afternoon.
that's fine. Any objection, Mr. Sanders?
No objection, Your
All
Honor.
right, the court in this cause number having received and accepted the defendant's plea of guilty of the offense of engaging in organized criminal activity, first-degree felony. The court, following the plea agreement, the recommendation of the state finding the defendant's plea of guilty entered to the indictment was entered freely, intelligently, knowingly, and voluntarily. The court, having found the defendant guilty of the offense of engaging in organized criminal activity, first-degree felony as alleged in the indictment, the court, following the plea agreement, the recommendation of the state by Mr. Giral, the court does assess the sentence at 8 years in the Texas Department of Corrections Institutional Division, assessed with credit for time served. The court has taken into consideration at 1245, indictment number 241-2013-20. So it'll be dismissed by the state. In legal, reasonable, or formal sentencing. Finding none, the court formally pronounces the sentence. The court finds the defendant guilty of the offense of engaging in organized criminal activity, first-degree felony as alleged in the indictment. Follows the plea agreement, assessing the sentence at 8 years in the Texas Department of Corrections Institutional Division, assessed with credit for time served. Courts considered cause number 241-2013-20 under 1245. Sentence is formally pronounced. Also, Mr. Lennis, I mentioned earlier, but you have signed a waiver giving up your right to appeal. Do you understand that?
Yes, sir.
and you signed a waiver giving up your right to file a motion for new trial. Are you presenting that waiver of appeal and waiver of your right to file a motion for new trial with the court now?
Yes, sir.
All right, the court receives and accepts a waiver of appeal, receives, and accepts the waiver of right to file a motion for new trial. Be the order of the court now, Ms. Atlantis, you will be continued to the custody of the sheriff until you can be transported to the Texas Department of Corrections Institutional Division to serve the 8-year sentence assessed by the court following the plea agreement in the case. The 8-year sentence is assessed with credit for time served you've got in the Smith County Jail. I have considered under Article 1245, an indictment cause number 241-2013-20. So one of the state's attorneys will dismiss that one. Do you understand all this we're done today, Ms. Atlantis?
Yes, sir.
You have anything else, Mr. Sanders?
No, Your Honor.
You have anything else, Mr. Gerald?
No, Your Honor. I apologize for the bad internet connection.
No, I don't make any difference. Thanks for being here, Mr. Gerald. We're in recess.
Are you excused?
Yes, thank you very much.
Thank you, Your Honor.
Yes, sir. That's it, Mr. Sanders. Thank you.
And Judge, I think I have one more that's on a pretrial.
Oh, good. Okay.
Yeah, she looks like she's having issues connecting,
Oh.
Jeff, but I'll give her.
Oh, okay.
Miss Alanis,
Yes.
will you let the deputy know that I need Zachary Drake, please?
Okay.
Thank you.
Is that, oh, thought we had her for a second. Is that your client, Mr. Sanders?
No, the person in jail, that's Zachary Drake.
I was talking about this Galaxy A32 5G person.
That was my dad.
Miss Clark, if you can unmute, please.
Okay.
You are Miss Clark, correct?
Yes.
Okay, Judge, we're ready.
Okay, I actually can't see her because I've got a sign up that says this meeting's being live streamed, but I can hear her. This is in cause number 241-1057-21, State versus Karina Rochelle Clark, present before the court by Zoom with her attorney, Mr. Jeff Sanders, present before the court by Zoom. Are you who represents? I've got Mr. Roberson up on the screen too. Mr. Sanders, you represent this defendant, correct?
Yes, Your Honor. We were hired Monday, and Mr. Robertson signed a motion to substitute along with us and our client. And Judge, we were just basically we just need to, I think, have the order to substitute signed, and we were going to ask if we could have additional 30 days to get discovery and meet with our client and talk to the state to see if we can resolve the case.
All right, have you filed a motion to, I'm sure you have, Mr. Sanders, to substitute in for Mr. Roberson?
But it should be
Yes,
up
Your
there in the file.
Okay. Well, your motion to substitute in for Mr. Roberson, who is the defendant, Karina Clark's court-appointed attorney, is granted. I'll sign it today. That's the actual order substituting counsel, which is granted by the court. It says Jeff Sanders is substituted as counsel for the defendant in place of court-appointed attorney Clifton Roberson, who is relieved of obligations and duties as counsel for the defendant in this case. All right, defendant is I believe she's incarcerated. I've got to sign
No,
up.
Judge, she's out of jail. She's on the screen.
Okay, I'm sorry, I can't see anything because it says it's being live streamed. So, all right, the defendant's present, obviously on bond. Looks like she's on a $30,000 surety bond by Texas Outlaws bail bonds.
Yes.
So she's continued on her $30,000 surety bond. All right, so Ms. Anderson, what have you got?
Your Honor, I don't have anything. This is just, we're asking you to grant the motion to substitute for Mr. Sanders, and we need a new plea docket date.
All right, I'm signing the motion order substituting counsel, Mr. Jeff Saunders, in as counsel for the defendant. Denise, can you give us a date?
Wednesday, December 1st at 1:30.
Wednesday, December the 1st at
At
1:30.
1:30.
Wednesday, I'll put that on the docket sheet. Wednesday, December the 1st at 1:30.
And that will be an in-person hearing.
All right, that will be an in-person hearing. So Ms. Clark, I need to be sure you understand you're on the Texas Outlaws bail bond in the amount of $30,000. One of your conditions of your bail bond now is, as it always is in these cases, is that you must personally appear before the court, the judge, on Wednesday, December the 1st at 1:30. That'll be with your attorney, Mr. Jeff Saunders, and state's attorney, for the court to cite the case for trial and take up any pretrial motions at that time. Do you understand that, Ms. Clark?
Yes.
All right,
Yes,
now
sir.
and that, as I've said once, but I want to be sure you understand, that's now a condition of your bond. So if you did not appear back before the court in person in the courtroom on Wednesday, December 1st at 1:30, it would cause the court to have to forfeit your bond and increase the bond substantially and issue a warrant for your arrest. You understand all that?
Yes, sir.
Anything else today, Mr. Sanders?
No, Your Honor.
Anything else, Ms. Anderson?
No, Your Honor.
We're in recess. Let me see all I've got on the screen. That's somebody up there by Galaxy. Who's that gonna be?
That was your last case, so I guess I should go ahead and sign out.
Oh, yes, ma'am.
Yes, ma'am, you may.
Okay,
Ma'am,
thank
you
you.
may sign off. I'm sorry. Thank you.
That's okay.
All right, we're on the record now in cause number 2410969-21, State versus Zachary Drake, on a charge of aggravated assault with a deadly weapon, second-degree felony as alleged in the indictment. He's in jail on the screen by Zoom with the court. His attorney, Mr. Roberson's on Zoom with the court. Ms. Anderson is this attorney's on Zoom with the court. Is this one of your clients, Mr. Roberson?
It is, Your Honor.
All right.
Waive before I'm reading the indictment, Your Honor. His name is correctly set forth in the indictment. Knows what he's charged with, the range of punishment. Ain't gonna change his plea from not guilty to guilty, Your Honor.
All right. Just for the record, I know there's an affidavit of non-prosecution in here from James Marks. I guess both counsel have seen it. Obviously, I'm just putting that in the record. Obviously, that's not binding on the state, but anyway, I've got one. So I need to get you, Mr. Drake. I've got someone else on the screen. Says James Marks, witness. Is he involved? Is he a witness on this plea?
He is, Your Honor, and the reason he's in it on the plea, Your Honor, is the court filed the recommendation that it's alleged victim in the case, which is my client's father. And he wished that for his son to come back home and live with him. And so the court would have to make an exception that he can go live with his father, even since his father's a victim, Your Honor.
Yeah, that's good. Let's see. Zachary Drake did then and there intentionally, knowingly threatened James Marks with imminent bodily injury by threatening him with a knife, and then and there use or exhibit a deadly weapon with a knife during the commission of the offense. All right, we'll take that up after we get the plea done and get down to the conditions. Did I get Mr. Drake, did I get you sworn in? You're sitting over in jail and I can see you. Did I get you sworn in?
No.
Raise your right hand for me. Do you solemnly swear the testimony you'll give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
All right, 2410969-21 State versus Zachary Drake sworn in under oath in jail. His attorney, Mr. Roberson's on the Zoom. Ms. Anderson's on the Zoom. Court Probation Officer Marcella's on the Zoom. All right, I've got some matters I need to go over with you here. Mr. Drake, be sure and tell me if there's anything you don't understand, okay? I've got a set of plea documents, Mr. Drake. I have to go through and identify for the record. They're signed by your attorney, Mr. Roberson, signed by Ms. Anderson, state's attorney. There's a signature on the line above where it says defendant. I actually can't read it, and that's nothing unusual about that. But did you sign all of these plea documents and swear to the ones that show they're sworn to?
I can't see it. Your green screen is blocking it out. But if this the papers that you guys sent over yesterday, yes.
Okay, so you went over each one of these plea documents with Mr. Clifton Roberson, your attorney, so you understand each document that you signed and now signed and sworn to. Is that correct?
Yes.
Okay, let me raise your right hand one more time, because let me include in the oath, since I understand a little bit more about how we're doing this one now. You solemnly swear your testimony will be the truth, the whole truth, and nothing but the truth, and that all these plea documents signed which show they're sworn to by you are being sworn to by you now under oath, freely, intelligently, knowingly, and voluntarily. Is that correct?
Correct.
All right, Mr. Drake, I'm going to go through and identify these plea documents. They may or may not make their way up on the screen, but the first one is your plea agreement and agreed punishment recommendation, signed by you, signed by State's Attorney, Ms. Anderson, by your attorney, Mr. Roberson. The plea agreement, according to this document, is for you and her plea of guilty to this secondary felony offense of aggravated assault with a deadly weapon. Ms. Anderson, State's Attorney, is going to recommend your sentence at 4 years deferred adjudicated probation. Part of the plea agreement pursuant to Article 1245, the court will consider an offense of criminal mischief under a DA. There's actually not a DA cause number. Restitution to apply in the aggravated assault case. So I'm not sure. Is there restitution in this case, Ms. Anderson?
Your Honor, not
Just
that I,
restitution in the criminal mischief. Since criminal mischief is going to be 1245, they consider that restitution in with the aggravated assault, Your Honor.
So is the restitution going to be paid as part of the plea agreement on the criminal mischief? Is
Yes, Your Honor.
that what you're trying to get in? Okay. State's recommending 4 years deferred adjudicated probation. Mr. Drake, that's your plea agreement. If you plead guilty, I'm going to follow the state's recommendation, withhold the finding of guilt, place you on deferred adjudicated probation for 4 years. You understand that?
Yes, sir.
Now, you understand the offense, aggravated assault with deadly weapons, second degree felony, correct? 2 to 20, fine
do.
up to 10,000. You understand that?
Yes, sir.
You understand when I place you on this 4 years deferred adjudicated probation, you'll have about 70 or so terms and conditions. If I receive a violation report from your probation officer telling me that you have violated any of these conditions, I'll issue a no bond warrant for your arrest. Then when you turn yourself in and you're apprehended, you'll be back before the court, and the judge will hear evidence on what's called a state's motion to adjudicate. And if the state proves to the judge, not a jury, you have violated any of the terms and conditions of your deferred adjudicated probation, the judge will go back, find you guilty of the offense of aggravated assault with a deadly weapon, and then the judge can sentence you up to 20 years in the Texas Department of Corrections Institutional Division and a fine of up to $10,000. Do you understand that?
Yes.
All right, that's your first plea document, 4 years deferred. The criminal mischief being considered by the court, restitution to apply in the aggravated assault case. That's what the plea papers say. Anyway, I'll follow the plea agreement, says your sentence 4 years deferred adjudicated probation. You'll go on deferred adjudicated probation. You can be on it for up to obviously 4 years. I want to just I like to be sure going in on these deferred, you understand if you violate any of the conditions, you'll be back on a no bond warrant in jail, and then before a district judge, and the district judge, if he or she finds you violated any of your 70 or so conditions, will grant the state's motion, go back, find you guilty, and then the judge can sentence you up to 20 years. And the judge will make an affirmative finding you used or exhibited a deadly weapon. And that's a mandatory halftime. So you understand what you're looking at?
Yes, sir.
All right. In addition to the plea agreement, there's an acknowledgement of admonishments. The acknowledgement of admonishments is signed, but it says the offense for which the defendant's charged aggravated assault with a deadly weapon and the range of punishment for such offense, that's blank. I'm going to fill in with state's counsel and defense counsel, not less than 2 to more than 20 years and a fine of up to $10,000. Understand, counsel?
That is correct, Judge, and I just missed that page. I'm sorry.
That's all right. Next document, you understand, Mr. Drake, you're waiving giving up your right to a jury trial?
Yes.
All right. You also understand you're waiving confrontation with witnesses and agreeing to stipulate testimony?
Yes.
That agreement to stipulate testimony is in the next document, the stipulation of evidence signed and now sworn to by you, signed by Mr. Robeson. That stipulation of evidence states too, is a written judicial confession under oath by you to all the allegations and the charge in the indictment. Do you understand that?
Yes.
There's an agreement to stipulate testimony. You understand also, Mr. Drake, by another document, you are waiving giving up your right to file a motion for new trial, and you're waiving giving up your right to file a notice of appeal. Do you understand all these documents?
Yes.
Understanding all these documents, do you still wish to go forward on your plea of guilty to the indictment before the court without a jury?
As long as the condition of being able to contact and be around my father is met, yeah.
Run that by me again.
As long as I'm allowed to contact and be around my father, yes.
Well, we hadn't got there yet.
You're
That's,
asking me to plead
that's,
guilty?
as I understand what Mr. Roberson has said, what was the agreement on that? That he will be able to have contact with his father, Mr. Roberson, and Ms. Anderson?
And Judge, that's why we have the father present for him to give testimony that he wants his son back at home and that
Okay.
he wants to waive that a condition of probation that his son cannot be around him, Your Honor.
All right.
And I think that's an issue for the court. I mean, the state's not going to object, but I don't think his plea can be predicated on that because that's a sentencing question.
Well, that's exactly right. In other words, Mr. Drake, what state's counsel is saying, and that's correct, your plea to this offense is not predicated on a condition that you can have contact with your father. What that means is, what you're doing is, if you want the court to follow the plea agreement, if you plead guilty to the offense of aggravated assault with a deadly weapon, second-degree felony, state's counsel, Ms. Anderson, is going to recommend to the court your sentence be assessed at 4 years deferred adjudicated probation and restitution. It will be ordered to apply over an aggravated assault case, but Ms. Anderson is exactly correct. Your plea cannot be conditioned on you being allowed to have contact with your father. You follow me on that?
Yes.
That means if you do plead guilty, and I accept your plea of guilty, finding it was entered freely, intelligently, knowingly, and voluntarily, and then I withhold the finding of guilt and place you on 4 years deferred adjudicated probation, I may deny the request, and I may say, I have the authority to say, no, you cannot have any contact with your father. So your plea of guilty is not conditioned on, that's what I want you to be able to understand. It's not conditioned on you being able to have contact with your father. Do you understand that?
Yes.
All right, all these plea documents have been signed or signed and sworn to by you. You got your plea agreement, 4 years deferred adjudicated probation. The second one I mentioned earlier, but the sentencing range will have to be filled in by the court, 2 to 20 and a fine of up to 10,000. Do you understand that?
Yes.
You understand you're waiving giving up your right to a trial by jury, correct?
Yes.
You're waiving giving up your right to confront witnesses and agreeing to stipulate testimony. You have signed and sworn to a stipulation of evidence, which is a written confession under oath by you to all the allegations and the charge in the indictment. You understand that?
Yes,
There's an agreement to stipulate testimony. You're waiving your right to appeal, waiving your right to file a motion for new trial. Do you understand all these documents?
yes, sir.
All right, I'm gonna go through now and I'm gonna ask you some questions. They're pretty straightforward. Just let me know if there's any of them you don't understand. Do you read, write, and understand English?
Yes,
Have you consumed any alcohol in the last 24 hours?
no,
Are you under the influence today of any drug, narcotic, controlled substance, toxic, or have any of those substances in your system?
no,
Have you ever been confined in a mental institution or under psychiatric treatment?
uh, no,
Okay. Do you understand everything you're doing in court today?
yes,
Have you been over everything about the facts of your case, all your plea documents and everything you're doing in court today with the court appointed attorney, Mr. Roberson?
yes,
Is he competent, Mr. Roberson?
He is, Your Honor.
Yes, been competent, Ms. Anderson.
No, sir.
All right, Court notes State's counsel signed her consent to approve the waiver of trial by jury. Court approves the waiver of trial by jury. All the other waivers in the case signed or signed sworn to by the defendant, signed by his attorney. All right, now, you do understand, Mr. Drake, all the allegations and the charge in the indictment against you and the full range of sentencing and all your plea documents. Is that correct?
yes,
Do you have any questions for me about anything?
no, sir.
All right, in cause number 241-0969-21, what is your plea today to the indictment charging you with aggravated assault with a deadly weapon? A second-degree felony is alleged in the indictment.
Guilty.
Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Yes,
Anyone threaten you in any way, promise you anything, or coerce you, make you plead guilty?
no,
Are you entering your plea of guilty to the indictment today freely, intelligently, knowingly, and voluntarily because you committed this offense charged against you in the indictment?
yes, sir.
Are you entering your plea of guilty to the indictment today because you have any type delusion in your mind or some type unrealistic hope of pardon, parole, or leniency?
No,
The court does receive and accept your plea of guilty. What do you have, Ms. Anderson?
We offer states 1, the plea packet with signed waivers and admonishments, states 2, the signed and sworn stipulation of evidence, as well as states 3, the discovery compliance documents.
No objection, Your Honor.
With no objection, states exhibits 1, 2, and 3 are admitted into evidence. The court finding of the defendant's waiver as rights, execution of all the other documents were all done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find the defendant's plea of guilty entered to the indictment was entered by the defendant to the indictment freely, intelligently, knowingly, and voluntarily. However, the court does at this time withhold a finding of guilt as to the defendant. Will move on to sentencing.
We offer states 4, an electronic copy of the written discovery in this case.
No objection, Your Honor.
States 4 is admitted into evidence with no objection. Anything else, Ms. Anderson?
Not from the state, Your Honor.
The court in this case then, based upon the defendant's plea of guilty to the offense of aggravated assault with a deadly weapon, as alleged in the indictment, the evidence presented and admitted into the record by the court. The court having received and accepted the defendant's plea of guilty and admitted the evidence in the record, the court does finding the defendant's plea of guilty was entered to the indictment freely, intelligently, knowingly, and voluntarily. The court does receive and accept the defendant's plea of guilty. However, the court does withhold a finding of guilt at this time. The court does make, and it will be on the judgment, an affirmative finding that the defendant used or exhibited a deadly weapon with a knife that in the manner and means of its use and intended use was capable of causing death and serious bodily injury during the commission of or immediate flight from said offense. Those allegations, that finding by the court, will be included in the judgment of the court. The judgment of the court will assess the sentence at 4 years deferred adjudicated probation. I have a waiver giving up your right to appeal, waiver giving up your right to file a motion for new trial. Mr. Roberson, are those being presented to the court now?
Yes, Judge, we present that waiver of appeal and motion for new trial to the court, Your Honor.
The waiver of appeal is approved by the court. Waiver of right to file a motion for new trial received and accepted by the court. Now, Mr. Drake, the court has followed the plea agreement, followed the recommendation of the state, withheld a finding of guilt, assessed your sentence at 4 years deferred adjudicated probation. that judgment will have in it the court that has made an affirmative finding that you used to exhibit a deadly weapon because you stipulated to it, admitted it in your sworn stipulation. What if you serve out the 4-year term, do not violate any of the terms and conditions of your deferred adjudicated probation, the state will dismiss the indictment against you. Do you understand that?
Yes, sir.
If any time while you're on this deferred adjudicated probation up to 4 years, if you violate any term or condition of your deferred adjudicated probation, your probation officer will send to the state, and then the state will file with the court what we call a motion to adjudicate your case. That would allege violations of your deferred adjudicated probation. It would trigger a no bond warrant for your arrest. Once you were in jail or apprehended, turned yourself in, the judge of this court would conduct a hearing. It would not be before a jury. The judge of the court would conduct a hearing. And if the judge determined you had in fact violated any of your 70 or so terms and conditions of your deferred adjudicated probation, the judge of the court would grant the state's motion to adjudicate. Just a legal word, meaning the judge would go back, find you guilty of the offense of aggravated assault with a deadly weapon, a second-degree felony, as alleged in the indictment. And then the judgment placing you on the deferred adjudicated probation for 4 years would already have in it affirmative finding from this court that you used or exhibited a deadly weapon to wit a knife as alleged in the indictment. So the judge could assess your sentence anywhere up to 20 years in the Texas Department of Corrections Institutional Division, fine of up to $10,000 if you violate any of these terms and conditions and it's proven to the judge. Do you understand that?
Yes, sir.
I've made this affirmative finding, even though I'm following the recommendation and placing you on deferred, because the judge will have this affirmative finding that you use or exhibit a deadly weapon. Hopefully it won't happen, but if you get down to the point where you violate any of your 70 or so conditions, the no bond warrant's triggered, you're in before a judge, not a jury, and the judge finds you violated any of your conditions, the judge will go back, grant the state's motion to adjudicate, finds you guilty of the offense charged in the indictment, aggravated assault with a deadly weapon. The judge will look at the judgment entered and see the affirmative finding based on your stipulation that you use or exhibit a deadly weapon. Then the judge can assess your sentence all the way to 20 years in the Texas Department of Corrections Institutional Division with a fine of up to $10,000 because you were on deferred. Do you understand that?
Yes, sir.
Then the judge will be looking at the judgment I entered and see the affirmative finding that you used or exhibit a deadly weapon to with a knife. Then when the judge assesses you time, years in TDC, that judge will make at the time, if this happens, hopefully it doesn't, at the time the judge says you sentence in TDC, that judge will be looking at a judgment to see I made an affirmative finding and used or exhibited a deadly weapon, a knife. And then the judge, let's say the judge gives you 10 years in TDC. The judge, the sentencing judge at that point would make an affirmative finding on the judgment. An affirmative finding on the judgment assessing time to do in TDC means straight up half time before eligibility for parole. So if you get down to that point, a judge can give you 20 years. Let's just say the judge gives you 10. That affirmative finding will be there. The judge will make it again. You get 10 years in TDC, you'll do 5 flat day for day before you come up for parole. You with me on this?
Yes, sir.
All right, what else do you have, Ms. Anderson?
I don't have anything else today from the state, Your Honor.
Anything else, Mr. Robertson?
Yeah, Judge, we want to put the father on James Marks.
Oh, yeah, thanks, Mr. Robertson. Go ahead before I get to Marcella and what the defendant needs to do. Go ahead, Mr. Robertson. I've already sworn, I believe I've already sworn Mr. Drake in.
Right, but yeah, you need to swear his father in, Your Honor, James Marks.
Okay, well, let me swear Mr. Marks in. Mr. Marks, if you can hear me okay, raise your right hand. I'm not sure he can hear me, Clifton.
Oh, Mr. Marks.
I don't think he can hear us.
All right.
Is he like,
Yeah. Oh, can you hear us?
he can't, I don't think he can hear us. He can't hear us.
Uh-oh. Mm.
I don't know where he's on, but he can't hear us. That's the thing.
I accept. Is Denise in there? Mm.
Oh, she's in her office. Hang on.
But there's I
She's
mean, I
on-
can send him a chat, but I don't know if he knows how to.
Do we know where he is, Clifton? She's trying to send him something.
I don't know, Judge, he's on the phone.
Okay. I know what you're trying to get on the record. I assume you're gonna ask his dad if he was agreeable to his son being able to have contact with him. Is that correct?
Yes, Judge. he informed me.
Obviously, there'd normally be a no contact provision. I don't know. So see if Denise can get in touch with him.
Well, Your Honor, according to Mr. Chamness, he told me he'd talked to Mr. Marks before and that he would not, the state would not object to.
We can just clear this up. Are you on, Mr. Chambliss?
I am, Your Honor.
Go ahead.
In discussing the case with Mr. Roberson, obviously I was well aware that the father had filed an affidavit of non-prosecution. I had told Mr. Roberson that because of the nature of the offense, that as long as the father was present at the plea hearing and that he understood why we typically require there to be no contact on an aggravated offense between the victim and the defendant, and that he understood those and he voluntarily was waiving the protection that a no contact order would give. That because they are father and son, that we would not oppose it, but that I wanted him to be present at the hearing so that if the court had any questions for
I am here. I'm good. I can hear you.
Go ahead and question him, Mr. Chambliss.
Thank you.
Okay. Mr. Marks, can you hear me?
I can hear you.
Okay.
Yeah.
You understand that as part of this plea agreement, normally there would be a no contact provision that would exist between the defendant and the victim. And in this particular case, the defendant is your son, correct?
Correct.
Okay. And obviously that's done because we want to ensure the safety of the victim in a case, especially when it's an aggravated offense. And you understand that as well.
I do.
Okay. And in negotiating this case, obviously you weren't present for the conversations that I had with Mr. Roberson, but Mr. Roberson got in contact with you and explained to you that I would not oppose you having contact with your son as long as you were willing to tell the court that you understood what the protections would be, but that you were voluntarily willing to waive those protections so that you could have communications with your son.
Correct.
In addition, there are potentially some issues that we're going to have evaluated by probation in regards to potential substance abuse or alcohol abuse that is going to be evaluated with your son, correct?
Yes.
And one of the things that Mr. Roberson and I had talked about was that you felt like the likelihood that he would have a better result on probation would be enhanced if you were able to have contact with him for those reasons.
Oh, absolutely.
Okay. I don't have any further questions, Your Honor.
Okay, the court approves the waiver of the no contact provision. Marcella, he will be on intensive supervision for the first year. Mr. Drake, the defendant, not your dad, that means that, well, your dad's Mr. Morris, but what I want, that intensive supervision, your probation officer, you'll be assigned to an intensive supervision officer. That's going to be more reporting, more drug testing, more of everything for the first year. Generally, if individuals clear the first year of intensive supervision, they make it. But you're going to have to bear down that first year because you'll be with an intensive supervision officer. You'll be randomly drug tested quite often. And you may well be admitted into, it sounds like you will be, an outpatient treatment for drug abuse, addiction, and treatment. You understand that?
Yes, sir.
Okay, so they'll get you the drug abuse treatment you need. It'll be there for you, but who would be the only person that can make it work?
Me, but
That'd be you. So they can put you in all the intensive treatment, all the courses and recommend everything else that can be done. But if you don't bear down, and I don't have a pre-sentence, but it sounds like drugs are in here somewhere. If you don't bear down, get off
sir?
the drugs, you'll end up in the penitentiary, and you will not enjoy the penitentiary officer.
Sir?
Judge,
I have no history of drugs.
it's alcohol abuse, Your Honor.
I'm sorry.
It's alcohol.
Well, alcohol, here's the deal. Alcohol is a drug. Alcohol, you get addicted to alcohol just like you get addicted to heroin. Alcohol is a drug, and it can send you to the penitentiary just as quick as heroin, okay? So you got to bear down on your outpatient treatment, or you'll end up getting your probation revoked, and you'll be in inpatient treatment on your way to TDC. Okay, and I'm telling you this up front. And believe me this, now I'll be here another couple of years and a new judge will be in, but I don't want to hear anything from my intensive supervision probation officer who sends me reports about problems between you and your dad. Do you understand that?
Yes, sir.
If there's any problems reported to me, I'll get the evidence on it, but I'm allowing you to have contact with your dad on the assumption that you're going to respect your father. You're going to do what your father tells you. Okay? If you don't respect your father, which I'm going to expect you to do, as far as I know you do, if you cause your dad any problems in any way, I'll jerk that condition. Okay, you understand me?
Yes, sir.
And you'll be looking at the penitentiary. That's a condition of your deferred. I'm telling my probation officer right now that you can have contact with your dad, but you're to conduct yourself in a manner where you don't cause your dad any problems at home or anywhere else. You with me?
Yes, sir.
You're ordered into intensive outpatient treatment for alcohol. That's not lockdown. It's outpatient treatment, Marcella.
Yes, Your Honor.
I don't know what else to do, Mr. Drake. Your dad's doing everything he can do. He's letting you come back home. I'm giving you every opportunity on this deferred. I will say this, Mr. Drake, if you end up the TDC, Texas Department of Corrections, you won't like it. And there's only one person that can send you there. And who's that?
Me.
You, that's correct. Anything else, Ms. Anderson? Anything else, Mr. Robertson?
Judge, if Marcelo was informed him that if when he's released from jail, what he needs.
Yes, Marcella, I was working my way down to that. I wanted to emphasize those others. Explain to him what he has to do when he bucks out of jail. Listen to this closely, Mr. Drake.
Yes, Your Honor. Mr. Drake, immediately upon being released from Smith County Jail, report to the Smith County Probation Department. When you get to the Probation Department, sign in new from court or intake officers will meet with you and you'll be assigned a supervision officer. If you're released before 5 today, then we'll see you today. But if you're released after 5, we'll see you at 8 o'clock in the morning. And we're located in the same building that you were reporting to pretrial.
Okay.
You understand all that, Mr. Drake?
Yes, sir.
All right, anything else, Ms. Anderson?
No, sir.
Anything else, Mr. Robertson?
No, Your Honor.
All right, thank you, Mr. Marks, for being here. We're in recess.
Mr. Drake. Mr. Drake.
Yes, ma'am.
Actually, as soon as you book out, if you will come to the courthouse to the second floor to the 241st court office, I need to get your prints. And then I'll send you over to probation.
All right.
And if you'll let the deputy know, I need Mr. Betancourt next, please.
Denise, is Betancourt at low risk?
My bad, sorry. I forgot I've got to switch over. If we can have Buford Dixon.
Yeah, that would be quick. Buford Dixon. What about Tanya Summerville? So we can put her on the
Either one of
record.
them I can do next. And it looks
Okay.
like I have Miss Somerville.
Yes.
Clifton,
Yeah.
I'm sorry. What are we doing on Miss Somerville?
Well, you know what? We're gonna put.
We
it on
don't
the
know,
record.
right? We're about to find out.
Yes, because I tried to Zoom.
Oh,
with
I
her.
remember. This is the letter thing. Got it. Thank you. Sorry about that.
No problem. Oh, and I did get the subpoena and I signed off on it.
Thank you. I appreciate that. That was probably easiest for everybody. Yeah, we're gonna do this one first. It's just an announcement.
Okay. All right, we're on the record in cause number 2410445-20 State versus Tommy Somerville. What'd I say? If I start hollering at me. What's the name?
It's Tanya, Your Honor.
Okay, well, my file, hang on. I'm just going by what's on the file. Well, I probably should have looked inside. The docket sheet, 2410445-20 State versus Tanya, Tony Renee Somerville. Defendant, she's on the screen with Mr. Robeson, her attorney. It's on an indictment charging and Ms. Anderson's on the screen. Indictment charging the offense of unauthorized use of motor vehicle, state jail felony. All right, what do we got on this one?
Judge, can I just put this on the record? I was appointed to represent her on August 11th of 2021. I had made several attempts at the jail to Zoom with her. And on August the 17th, 2021 at 9 a.m., they told me she was in quarantine. I couldn't Zoom with her. On August the 23rd, 2021 at 1 p.m., I tried to Zoom with her. They said she was in quarantine. Again, on August the 24th, 2021, I tried to Zoom with her. They said she's still in quarantine. The same thing on August the 30th at 1 o'clock. They said she was still in quarantine. And then I tried to Zoom with her on September 6th, 2021. They said she was in quarantine at 9 o'clock. And then on September 17th, 2021 at 9 a.m., they said she refused to come down and talk with me, that she was out of quarantine. And then on 10/18/2021 at 3 p.m., I tried to Zoom with her again. They said she refused to Zoom with me because she wrote me a letter and I didn't respond to the letter. And I was trying to Zoom with her to go over everything and she refused to come down.
Well, looks like, looking at the indictment, the charge unauthorized use of a motor vehicle. Looks like the bond on the back of the indictment's $10,000 surety bond. So Ms. Anderson's here on screen also, along with, of course, probation officer. So there is a notation, April the 17th, 2020, the case was called for arraignment. Defendant failed to appear. So does anyone know what happened? I mean, she's in jail now. Is that why?
My understanding, Judge, that she was bench sworn in. I guess she was bench sworn in on some commitment or whatever. That's why she's in Smith County. However, like I said, I made several attempts to try to discuss her case with her, go over everything, and she was in quarantine. And then when she got out of quarantine, she would not see me via Zoom. So, Judge, I just need to let the court know that the only way that I can communicate with her through Zoom, and I need for her to talk with me so I can try to dispose of her case.
Well, that would all be correct. Ms. Anderson, you know anything about this?
I really don't, Your Honor. Just what Mr. Roberson informed the state that he hadn't been able to talk to his client yet, and why. There's an offer out. This is the plea docket date, but there's not much we can do if he hasn't been able to speak with his client or show her the discovery or give her the offer.
What is the offer?
The opening offer, I guess, or current offer is 15 months state jail.
All right. Is that the offer now?
That's the offer right now.
Okay, well, Ms. Somerville, were you sworn in?
No, sir, I was not.
Okay, just raise your right hand and where I can swear you in. I just got to ask you a couple of questions. Do you solemnly swear the testimony you'll give before the court will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, now the court has appointed you Attorney Clifton Robertson, who's got more years of experience representing defendants charged with crime than I can remember. And he's very well experienced, excellent attorney representing a lot of defendants right now who are incarcerated, like you, over in low risk. So why are you not communicating with Mr. Roberson? We need to get your case moving.
Well, due to quarantine, I did refuse to see him. So that way I'm not back on quarantine. I knew nothing of his so-called visits before the quarantine. I've only known of 2 visits from him, and I wrote him a letter so we can expunge this case, asking him to file a 1244A and get me time served from being at the county I was just arrested at and held for you guys, which you guys sent a paper for me to sign my own release with y'all. And that way they didn't understand the paperwork where I was at. So that way, when I'm released from where I was at, to sign my own release with you guys, and then I had 30 days to get in contact with you guys to let y'all know and set up a court date to where I could appear in court instead of me having to be brought here to go through all this.
Ms. Anderson, can you enlighten the court on what's going on?
No, sir. Unfortunately, I can't. This was
I didn't think so.
This was a non-arrest case. I'm not sure that when the warrant was served. I don't have anything in front of me about her out of county time. So I think these are things she's going to have to talk to her attorney about, and then he's welcome to discuss them with us.
That was the letter.
I'm sorry,
I sent
I'm
him.
still speaking.
Ma'am, let me tell you something. It'll work out a lot better if you'll just wait till Ms. Anderson finishes talking.
Yes, sir. Go ahead.
The offer right now is 15 months state jail.
All right.
And Judge, this is a situation. She wrote me a letter. I'm trying to respond to that letter via Zoom where we can communicate and talk, but I can't respond to the letter. She refused to Zoom with me, and I'm not going to sit there and write her a letter when we can do it through Zoom and I can get all the information from her.
Well, Ms. Summerville, Mr. Robertson, your court-appointed attorney, you're going to need to Zoom with Mr. Robertson so he can advise you on what you need to do. You got to need to talk to your attorney.
Yes, sir. That was the whole reason of the letter thing. He could have responded to me in a letter so we could have had this process in motion.
That, I'll tell you this, ordinarily, attorneys confer with their clients by Zoom if it's a situation where he cannot talk to you, and that's apparently the situation, you're in quarantine. But you communicate with each other by Zoom, and I'll tell you right now, it's for your benefit. So you talk to your attorney by Zoom rather than trying to write letters back and forth. That normally doesn't work. So when Mr. Robertson sets it up, and you'll know about it, he needs to Zoom with you to talk to you about this case. It's a state jail felony charge. I don't know, but I would think if you'll just Zoom with Mr. Robertson and talk to him about it, he'll probably go talk to Ms. Anderson and end up getting a plea offer on the case for you.
Yes, sir. I understand that. That's the reason of the letter, because they wasn't letting us leave the housing where we were being housed at. They wasn't bringing us to Zoom. Well, they were refusing all courts, all attorney visits and everything.
Here's the bottom line. You're certainly Zooming now. You're in a situation.
Oh, yes, sir.
Right. So Mr. Roberson's right here. So I'm sure he'll set it up where you can Zoom with him and talk about this case, see if something can be worked out with Ms. Anderson. She won't be on the Zoom where you're talking with Mr. Robertson, but right now you're just sitting there under a $10,000 surety bond. If you'll talk to Mr. Robertson by Zoom, I'm sure he'll get this case moving for you.
Yes, sir. That'd be wonderful.
All right.
I will set up a Zoom meeting with her, hopefully on Friday.
And Zoom meeting on Friday, and let Denise know if she can help you with it anyway.
Judge, it's been no problem. Jail works with me.
Oh, well, I figure that you Zoom with defendants in jail all the time.
Yeah, I will set up something with her on Friday, Your Honor.
All right, Ms. Anderson, you have anything else?
No, sir.
We're in recess.
Can we just reset this case?
Thank you, Ms. Anderson.
Defendants continued in custody on her bond.
Thank,
I put it on November 3rd.
Okay, thank you.
Ms. Somerville, if you'll let them know I need Mr. Dixon, please.
yes, ma'am, thank you.
Thanks. Mr. Roberson,
Yes, ma'am.
unless y'all worked something out, Miss McNaught's gonna need to come visit me and not be present on Zoom.
Okay, yeah, because it's a deferred for 3 years. Do you just want to reset it where we can do it in person? I go to the doctor this week and I think they're releasing me on Friday, hopefully.
She needs to come visit me today. She's violated by smoking meth recently or whatever you do with meth. And I'm assuming it's still in her system.
I will call her right now and tell her to come to the courthouse, to your office.
We might have to renegotiate her 3 years then, Clifton.
She reported on September 29th and tested positive for meth. She denied. It was sent to the lab and confirmed positive for meth at 8:42 and was something at 2:59. I don't know what any of that means, but.
Denise, could you send me a copy of that violation report, please?
Yes, ma'am. So she needs to come on down to the courthouse, Clifton.
Okay, all right, I will give her a call
So I will not be letting her in Zoom.
as soon as I finish this one.
Okay.
Okay, so you gonna give her a call, Clifton?
Judge, with this is a Buford Dixon, it's to make an announcement.
Buford, is that Buford Dixon on the screen?
Yes, Your Honor.
All right, court's calling 3 calls numbers, Allstate versus Buford Dixon, present before the court by Zoom with his attorney, Mr. Clifton Robertson. Ms. Anderson's present by Zoom. Mr. Chambliss is present by Zoom. Court's probation officer, Marcellus, present by Zoom. The court is calling calls number 241-1595-20. Indictment charging sexual abuse of a child, continuous victim under 14. Court's calling calls number 241-1596-20. State versus Buford Lee Dixon on indictment charging sexual assault of a child. Court's calling calls number 241-1597-20. On an indictment charging sexual abuse of a child, continuous victim under 14. The defendant is in jail under bonds. The bond in cause number 241-1595-20, sexual abuse of a child, continuous victim under 14, State versus Buford Dixon. That bond on that first degree felony on the back of the indictment is $500,000. The next case, 241-1596-20, State versus Buford Dixon. There actually was an alias capias on that one issued by the court. The present bond on that indictment appears to be $250,000 surety bond. And the third case, cause number 241-1597-20, State versus Buford Dixon, on sexual abuse of a child, continuous victim under 14. The indictment on that case, that bond on that indictment is $750,000 surety bond. Mr. Roberts is present, defendant's present in a, I don't know, is he's over, where is he downtown, Mr. Robertson?
He's downtown, Judge.
The defendant's by Zoom from downtown jail. Mr. Roberson's by Zoom from his office. Ms. Anderson's by Zoom from her office, and Mr. Chambliss is by Zoom from his office, and the court's probation officer, Marcellus, present by Zoom. Okay, I guess, Ms. Anderson, you're Mr. Chambliss. I guess you want to go ahead, Mr. Chambliss?
Your Honor, this is obviously there's two continuous cases, one sex assault. I will tell the court that the victim in the sex assault is the same as one of the continuous cases. There was continuing assaults alleged after the victim turned 14. So even though sexual assault can be a part of a continuous case, this sexual assault is actually a completely different allegation than what would have been one of the ones in the continuous. Mr. Roberson and I have discussed the case. We had some negotiations, none of which actually resulted in me making an actual offer of time. It was just more of a discussion of, is your client interested in pleading and resolving all of the cases, to which I had indicated that I would meet and talk with the victims and that I would run the cases concurrent. And that if he was interested in pleading, then I would certainly get a number to Mr. Roberson. It's my understanding that he wants a trial. And so I will get with the folks at the Child Advocacy Center, and I will also meet with my victims, and I will make a designation as to which case we are going to try first. And as soon as I do that, I will let the court know, and I will let Mr. Roberson know.
Judge, I was going to say, that's my understanding, Your Honor. My client has informed me that he does not want any plea negotiation, that he wants a trial. And when Mr. Chandler get with his clients, then we can figure out what date we can go to trial on, Your Honor.
All right, Mr. Roberson and Mr. Chandler, the court will just be waiting until after Mr. Chandler has an opportunity to contact some of his witnesses, see what dates available, and then he'll get back with you, Mr. Roberson, and the court will sign an order designating and setting one of these cases for trial on the date y'all work out. Is that where we are, Mr. Chandler?
Yes, Your Honor, and Mr. Roberson's aware of this fact, but one of the victims in the case is still undergoing therapy through the CAC, and because she's still undergoing therapy, I'm still getting records which need to be produced to Mr. Roberson as a result of that as well. So I'm trying to get everything in regards to that particular victim into Mr. Roberson's hands as soon as possible.
That is correct, Your Honor.
It would seem, Mr. Chamness, then when you get ready and Mr. Roberson's ready, we need to set, you're going to designate one of the cases. And then once you designate one of the cases, we need obviously to get it set for pretrial. And then we'll get obviously a special number 1 trial setting on it.
I think that would be the appropriate way to handle it, Judge.
I agree, Your Honor.
Yeah, all right, Mr. Robeson, Mr. Chambers. In the meantime, the defendant is continued in custody on all 3 indictments under all 3 present bonds the court just dictated into the record. Is there anything else for today, Mr. Chambers?
No, Your Honor.
Anything else for today, Mr. Roberson?
No, Your Honor.
All right, we're in recess pending the settings that Mr. Chamness and Mr. Roberson will get back with the court on, and I'll set them when state and defense agree to conduct a pretrial, and then we'll have one of them set for a jury trial. So appears that's all we can do today. So we're in recess.
Denise, we can ready to switch to low risk?
Correct.
Okay.
Mr. Dixon, you can let the deputy know that we're done with downtown.
All right, I'll give her a call, Amy.
Okay, Mr. or whoever's on at low risk, I can't see. Oh, hey, let me start with Wilson, please.
Okay.
Got headphones like this now. Ugh. Hello? I can't hear.
Sir, we haven't called your case yet.
Okay.
Denise, I'm ready when you're ready.
Take back to there.
Run it by me again, though. Just that it's May 26th.
Call it, but not refer back to there.
Okay, appears I need to call cause number 241-1972-20. State versus DeMarcus Wilson, present before the court from the North Jail by Zoom. Mr. Roberson, his attorney, is present by Zoom. Ms. Anderson, state's attorney, is present by Zoom. Court's probation officer Marcellin is on the screen. All right, what do we got here, Ms. Anderson?
Your Honor, we haven't called this case since the end of May. Back in the beginning of May, Mr. Wilson rejected the state's final offer of 25 years confinement in the institutional division. He had said he wanted to hire a private attorney, but then we came back about 3 weeks later on May 26th. He had not hired anyone. He still said he did not want to take the 25-year offer. And so I think that's where we are today, but Mr. Roberson may have more information.
All right, Mr. Roberson.
Just that's correct what Ms. Anderson said. We're in a situation, Judge, where it's 25 to life. They offered him the minimum 25. He rejected that and said he wants to get an attorney. Judge, we've been back and forth on if he hired an attorney or not. And it's been like a couple of months. We just need to know if he hired an attorney. If not, then we need to move on with this case, Your Honor.
All right,
whatever.
Mr. DeMarcus Wilson, Mr. Roberson, you're on the screen by Zoom. Mr. Roberson is your court-appointed attorney. Based on what Mr. Roberson has indicated to the court, have you retained your own attorney?
No, I haven't.
Have you hired your own attorney?
No, I haven't. I don't have the money to hire an attorney. I know the 25. I mean, I thought my wife was going to help me. Since then, I haven't seen her or talked to her or anything like that. So I'm kind of going through it with as far as getting me my own attorney or stuff like that. But I was wondering if I can be helped out. I'm a mental patient or whatever, and I haven't been on my medication for 2 years, and I'm not from here. I'm from Dallas, and I was receiving my medication at Lancaster Keys MHMR place, and I just moved here for Brooks's Warehouse. I was a good worker there, and I was wondering if there's any ways that someone can help me with like my case or something like that, because I wasn't trying to be drinking and driving. I was trying to go to work.
Okay, hold on a minute. Don't start going off any more about your case. Your court-appointed attorney, Mr. Clifton Roberson, is representing you. You need to be talking to him about your case. It's clear to the court from the record that Mr. Roberson is clearly Mr. DeMarcus Wilson's court-appointed attorney. He is incarcerated, and the bond on the indictment is $150,000 surety bond. So it's not a matter of whether or not what the court can do about someone else getting in touch with the defendant. Mr. Roberson represent the defendant. The defendant has every right, if he is financially able to do so, to retain to hire his own attorney, but he would have to retain and hire his own attorney. That attorney would have to then contact Mr. Roberson, and then the court would have to have a hearing to be sure he has retained an attorney. To be sure, until all that happens, Mr. Wilson, Mr. Roberson is your court-appointed attorney, and I'm not sure, shouldn't we be getting this case set for trial?
And Judge, this is a situation, the state has made an offer. They informed Mr. Wilson that they are not going to budge from that offer. Since he has not hired an attorney, if he refuses to reject the offer, then we need to set this for trial.
Yeah, that's the way it appears to the court. We just need to go ahead and get this case set for trial. The bond on this indictment's $150,000, and the indictment, the court having reviewed the indictment, it would certainly appear we need to go ahead and get this case set for trial. So, are you ready to go on it, Ms. Anderson? You ready for the state?
Well, Your Honor, I mean, I don't have a date, so I believe we had an August trial setting, but that jury trial date fell through, and so if we get a setting, the state will get its witnesses and be ready.
All right, well, let's get while we're all here on Zoom, let's get Denise to give us a dead drop for sure trial date.
Judge, I don't know if I can do that, but we can put him on the December 6th trial docket.
Okay, cause number 241-1972-20, State versus Marcus Wilson's on the December 6th.
Yes.
The situation we have on this case, and he's on the December 6th trial docket, but I don't know where he'll fall in the order, but it's real clear to the court that the defendant's not going to accept the state's offer, and it's going to be a jury trial. So Ms. Anderson and Mr. Chambliss should take a look at that, but we know this is going to be a jury trial by what I've been told today. You agree with that, Ms. Anderson?
Yes, sir.
So you and Mr. Chambliss get ready for trial. I don't know what else is on December 6th, but unless for some reason there's some other case that is a prior setting that's going, we need to get this one tried. You ready? Are you ready on it? Would you be ready on it December 6th, Mr. Roberson?
I should be ready, Judge. As I informed the court, I go to the doctor Friday, and I think he's going to release me, so I should be ready.
All right, Mr. Roberson, you just let us know what results there. Denise, I'm going to put it on the December 6th trial docket. My concern is I don't know what else is on that docket, but we know this case is going to trial. So Ms. Anderson needs to be ready on it, and Mr. Chambliss. I mean, I don't know whether or not there's another one that's set on December 6th. Do you know, Ms. Anderson? I mean, where y'all?
Judge, it's a trial docket. He'll be placed in the order by the number of days in jail.
Good enough. We're in recess.
Hey, excuse
Thank
me,
you.
y'all. Hey,
Okay.
is there any way that I can drop this down to a 15 and I'll sign and get out your way?
That's not up to the court. I don't have anything to do with that. All I can do is continue, and I'm putting you on the December 6th trial docket. I don't know where you will be on it, but you're continued in custody.
Well, Mr. Clifton Robeson, could you ask the DA, could he drop it down to 15 and I'll sign and get out your way?
He's already asked me and I've already said no.
That's the answer. No, I don't negotiate with the district attorney's office on pleas for defendants. That's your attorney, Mr. Roberson. He does that with the state's attorneys, Ms. Anderson and Mr. Chambliss, and they're on the screen. What I do,
I've been reading it. I've been meaning to write y'all and tell you, but I've been depressed. I'm sorry, but I am a mental patient, and I hadn't been on my medication, and I was trying to use that drinking, I guess, to cover my medication, but I was going to work every day, and I'm just saying, I'm just asking, please have mercy on me. And if y'all give me a 15, I'll sign and just go. And I want to go to trial.
Yeah, I'll tell you what you can do. You can discuss that further with Mr. Roberson, and Mr. Roberson can discuss it with the state. But state's counsel, Ms. Anderson's already said that they've got a rock bottom figure. What is it, Mr. Chambliss or Ms. Anderson?
Your Honor, and Mr. Roberson can confirm this. His initial offer was above the minimum. It was above 25. We negotiated the case down to 25, which is the minimum that he can get if his priors are proven. And the last time we had a pretrial hearing, I put on the record that I was not going to abandon any additional enhancement paragraphs. Nothing has changed. And so if this case goes to trial and he is found guilty, the minimum he can get from a jury is 25. If he wants to.
I'm sorry, Mr. Chambliss, I didn't mean to interrupt you.
If he wants to take 25, he can take 25, but I am not going to authorize anyone dropping any additional enhancements on this case.
Well, that's where we are. That's a rock bottom, 25 to do. That's the offer. It's not going below that. If it's not going to be a plea on that December 6th date, then it'll be subject to being a jury trial. I don't know, but my court coordinator does know what may be said above it that we also know is going to be a jury trial. The defendant's continued in custody on the bond set on the indictment with a $75,000 bond. The case is set by the court on the December 6th trial docket.
How much is my bond?
Your bond's $75,000 right now.
It's 75,000.
That's what it is on the indictment returned by the grand jury. Yeah, well, you talk, if you got any questions about that, talk to Mr. Roberson by Zoom. We're in recess, cases on the December 6th trial docket. I would anticipate if something else doesn't go, this is a doggone sure go, because we know apparently at this point it's going to be, certainly looks like a trial to the court.
I needed you to get in contact with me, Mr. Clifton Roberson, and I'll have a Zoom meeting with you because I'm thinking about signing for that 25.
Okay, Mr. Wilson, he'll be over to see you. If you'll let the deputy know that I need Mr. Betancourt.
Okay. All right. Thank you.
Go ahead. Well, I'm sorry.
Yes.
I'm sorry, I got this guy's name is
Let me mute myself. Well, for
I've already
one, I
got
did-
him in the file. He's our plea.
Oh, I'm sorry. You okay, you went past me.
I did. I got tired of listening to him.
And I get with you and Heaton, Elizabeth.
Counsel, actually, I've been handed another file along as we're on Zoom. Now I've got the file on Danny Betancourt. Obviously, that December 6th setting related to the previous case. What was that defendant's name that was just on Zoom?
DeMarcus Wilson, Your Honor.
Yeah, DeMarcus Wilson. You got him set for December 6th, Mr. Roberson, correct?
I do, Your Honor.
I think Denise got tired of listening to me on that one, so she just came and got that file, handed me another one. I think that means we're supposed to move on.
This is the last one, Your Honor. This is the last case.
All right, we're on the record in 24102-64-21. State versus, this is Danny Betancourt on a charge burglary of habitation. Looks like it's enhanced up to a first-degree felony if the priors are proven. Correct, Mr. Roberson?
That is correct, Your Honor, and I can inform the court that Mr. Betancourt waived the reading of the indictment. His name is correctly set forth in the indictment. He knows the range of punishment what he's charged with. It is a second-degree felony enhanced up to a first-degree felony. A judge he can change the plea from not guilty to guilty and a plea of true to the enhancement paragraph. And I think there's a recommendation of 10 years.
Okay, Ms. Anderson.
Your Honor, that is correct. There is a recommendation of 10 years with a 1245 of an evading charge.
Okay, so what's going to be, hang on just a minute. All right, so 24102-64-21, Mr. Betancourt, raise your right hand so I can swear you in. You solemnly swear the testimony you'll give will be the truth, the whole truth, nothing but the truth, so help you God.
Yes, sir. Yes, sir.
All right, Mr. Betancourt, you got a set of plea documents here. I'm going to go over those with you in a minute, but I need to ask you in regard to the indictment in this case. The first paragraph of the indictment charges you with the offense of burglary of a habitation, second-degree felony, carrying a sentencing range of not less than 2 or more than 20 years in TDC, and a fine may be assessed of up to $10,000. You understand that?
Yes, sir.
However, the third paragraph of your indictment alleges a prior felony conviction. Do you understand that?
Yes, sir.
Prior felony conviction, it alleges is tampering with physical evidence. And you have, I'll just read it to you because I'm going to ask you whether or not you plead true or not true to the allegations in the last paragraph of the indictment. If you plead true to these allegations that you have a prior felony conviction for tampering with physical evidence, then your full range of sentencing for the offense of burglary of habitation will be enhanced or increased up to first-degree range, not less than 5 years to more than 99 years of life, fine not to exceed $10,000. Of course, you have a plea agreement with the state. Do you understand that?
Yes, sir.
For 10 years, and I'm going to follow that. I'm going to read this last paragraph to you and ask you whether or not your plea is true or not true. It's further presented in and to said court that prior to the commission of the aforesaid offense, that on the 5th day of December 2016, and cause number 0071090-16, in the 7th Judicial District Court of Smith County, Texas, it's alleged you were convicted of the felony offense of tampering with physical evidence. Are those allegations true or not true?
Yes, sir.
Are they true?
True.
Are you entering your plea of true to these allegations freely, intelligently, knowingly, and voluntarily?
Yes, sir.
All right, the court receives and accepts your plea of true, making the full range of sentencing for this case now not less than 5 years and more than 99 years or life. In TDC, fine may be assessed of up to $10,000. Mr. Betancourt, you have a plea agreement in this case that if you plead guilty to this indictment charged with burglary habitation, Ms. Anderson, State's Attorney, is going to recommend your sentence at 10 years in the Texas Department of Corrections Institutional Division. You will have time credit assessed. Mr. Roberson's written on the papers 1/12/21 to the present. It's probably when you've been in Smith County Jail, since it's got S/C. Is that your plea agreement, Mr. Betancourt?
Yes, sir.
Is that it, Mr. Roberson?
Yes, Your Honor.
Recommendation, Ms. Anderson?
It is, Your Honor.
All right, all these plea documents, Mr. Betancourt, are actually signed by a signature I can easily read. Signed Danny Betancourt. Is that going to be your signature?
Yes, sir.
Okay. If I haven't already, let me give you this oath. Do you solemnly swear your testimony will be the truth, the whole truth, and nothing but the truth? And all these plea documents will show to be signed and then sworn to by you, are being sworn to by you now freely, intelligently, knowingly, and voluntarily.
Yes, sir.
All right, so your plea agreement, plea deal, Mr. Betancourt, if you plead guilty to this indictment, charged with burglary habitation, which has been enhanced up to a first-degree felony, state's going to recommend your sentence at 10 years in the Texas Department of Corrections Institutional Division. That would be assessed with credit for time served. Special condition would be you'd be ordered to pay restitution back to the owner in an amount determined to be due by a post-sentence investigation. Is that the plea agreement, Mr. Roberson?
Correct, Your Honor.
Is that your plea agreement, Mr. Betancourt?
Yes, sir.
All right, so you got your plea agreement, 10 to do with criminal, 10 to Texas Department of Corrections Institutional Division for 10 years, assessed with credit for time served in the Smith County Jail. You've got an acknowledgement of admonishments. All these are signed and sworn to by you. The admonishments give you the full range of sentencing, not less than 5 to 99 years of life, fine not to exceed $10,000. Your signature and your attorneys are right below the 7th admonishment. Do you understand all 7 admonishments?
Yes, sir.
All right, do you understand the next document? You waive and give up your right to trial by jury. Do you understand that?
Yes, sir.
You ask the court to go forward and hear your plea of guilty before the court without a jury. Is that correct?
Yes, sir.
Then you signed and sworn to a waiver of confrontation and agreement to stipulate. You signed a stipulation of evidence. That stipulation of evidence signed and sworn to by you, that's a written judicial confession or admission by you to all the allegations and the charge in the indictment. Do you understand that?
Yes, sir.
You've agreed to stipulate testimony. You signed a document along with your attorney waiving, giving up your right to appeal, waiving and giving up your right to file a motion for new trial. Do you understand that, Mr. Betancourt?
Yes, sir.
All right, understanding all these plea documents and your plea agreement for 10 years in TDC with credit, do you still wish to go forward on your plea of guilty without a jury?
Yes, sir.
Do you read, write, and understand English?
Yes, sir.
Have you consumed any alcohol in the last 24 hours?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir.
Have you ever been confined to a mental institution or under psychiatric treatment?
No, sir.
Do you understand everything you're doing in court today?
Yes, sir.
Have you been gone over everything about the facts of your case, all your plea documents, and what you're doing in court today with your attorney, Mr. Roberson?
Excuse me?
Well, okay, let me slow down a little bit. Have you gone over with Mr. Roberson
Oh, yes, sir.
all these plea documents you signed, as well as the indictment, the charge against you?
Yes, sir.
Is he competent, Mr. Roberson?
Yes, Your Honor.
You have severe incompetence, Ms. Anderson.
No, Your Honor.
All right, Court of North States Council signed her consent to approve the waiver of trial by jury. Court approves the waiver of trial by jury. All the other waivers in the case. Signed or signed sworn to by the defendant, signed by his attorney. All right, now you understand all the allegations in the indictment, the full range of sentencing, all your plea papers and your plea agreement. Is that correct, Mr. Bettencourt?
Yes, sir.
You have any questions for me?
No, sir.
All right, in cause number 2410264-21, what is your plea today to the indictment charging you with burglary of a habitation enhanced to a first-degree felony as alleged in the indictment?
Guilty.
Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Yes, sir.
Anyone threaten you in any way, promising anything or coerce you, make you plead guilty?
No, sir.
Are you entering your plea of guilty to this indictment freely, intelligently, knowingly, and voluntarily because you committed the offense charged against you in the indictment?
Yes, sir.
Are you pleading guilty because you have any delusion in your mind or some type unrealistic hope of pardon, parole, or leniency?
No, sir.
Okay. The court does receive and accept your plea of guilty to the indictment. What do you have, Ms. Anderson?
Your Honor, we offer States 1, the plea packet with signed waivers and admonishments. States 2, the signed and sworn stipulation of evidence, as well as States 3, the discovery compliance documents.
No objection, Your Honor.
No objection. States 1, all the plea papers. States 2, the signed sworn 2 stipulation of evidence. States 3, discovery compliance, all admitted into evidence with no objection. The court finding the defendant's waiver his rights, execution of all these documents were all done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find the defendant's plea of guilty entered to the indictment in this case was entered by the defendant to the indictment in this case freely, intelligently, knowingly, and voluntarily. The court does receive and accepts the defendant's plea of guilty to the indictment. The court does find the defendant guilty of the offense of burglary of a habitation as alleged in the indictment. David, sentencing.
We offer States 4 an electronic copy of the written discovery in this case.
No objection, Your Honor.
States 4 is admitted into evidence without objection. All the offense investigative reports, other discovery. Court in this case then having received and accepted the defendant's plea of guilty to the offense of burglary of a habitation as alleged in the indictment, enhanced up to full sentencing range of not less than 5 to more than 99 years in Texas Department of Correction, institutional division, or life. The court receiving and accepting the defendant's plea of guilty to the offense of burglary of habitation. The court does find the defendant guilty of burglary of habitation, enhanced up to a first-degree felony as alleged in the indictment. The court follows the plea agreement, the recommendation of the state is session of sentence at 10 years in the Texas Department of Corrections Institutional Division, assessed with credit as figured by Mr. Roberson from 1/12/21 to the present. Any legal reason for formal sentencing?
No legal reason, Your Honor.
Finding none, the court does formally pronounce the sentence. The court receives, accepts the defendant's plea of guilty to the indictment, finding it was entered freely, intelligently, knowingly, and voluntarily. The court does find the defendant guilty of the offense of burglary of a habitation as alleged in the indictment, enhanced to a first-degree felony. And the court, following the plea agreement and the recommendation of the state, assesses the sentence at 10 years in the Texas Department of Corrections Institutional Division, assessed with credit for time served. No fine, assessed, court costs are ordered paid. Restitution is ordered as determined by a post-sentence investigation conducted by a post-sentence office, probation department. Sentence is formally pronounced. Mr. Bettencourt, I have from you waivers giving up your right to appeal, waivers giving up your right to file a motion for new trial. Do you understand you're waiving those rights?
Yes, sir.
All right, those are signed by you and Mr. Robeson. The court receives, accepts, and approves the waiver of appeal, receives and accepts and approves the waiver of right to file a motion for new trial. Be the order of the court, Mr. Bettencourt is continued in the custody of the sheriff until he can be transported to the Texas Department of Corrections Institutional Division to serve the 10-year sentence assessed by the court following the plea agreement with credit for time served. Mr. Bettencourt, are you satisfied with the legal representation of your court-appointed attorney, Mr. Roberson?
Yes, sir.
All right, Mr. Bettencourt, good luck to you. Anything else, Ms. Anderson?
Your Honor.
We're in recess, counsel.
Thank you, Your Honor.
Your Honor, I think that's all for today.
Did you hear, is that all for today?
I think so. Mr. Roberson, I think we've covered everybody, haven't we?
I'm in agreement, and I think I'm gonna leave, and that's it, Judge.
That's it then. We're in recess.
All right,
Thank
have
you,
a
Your
good
Honor.
Mr. Betancourt, I need to speak to the deputy, please.
Okay.
Tell them to invoke their right to remain silent.
Hey, can you get me fingerprint? Can you get me
Hello?
fingerprints on Betancourt, please?
Yeah, 1 second.
And then just send them over or I'll have Stacy pick them up.
Okay.
Thank you.